Well, you bring up an interesting point about indefinite detention. A colleague of mine, some of you may know, Professor Madeline Morris at Duke, is writing a book about preventive detention. And there is a model for locking up people who are a danger to others, and it's an involuntary commitment under a mental, sort of a mental competency type of involuntary commitment. Might that model be possible? Because from what I understood of your proposal earlier, Amos, people who have already committed terrorist acts could be charged normal crimes, so people who are potentially a danger of committing terrorist attacks in the future, perhaps have joined Al-Qaeda and expressed their loyalty to that cause, maybe haven't committed crimes yet, but are a danger. Could they be locked up under some kind of model, a humane model, a model where they would get treatment and counseling, but on the basis that they are a clear danger to others? Any thoughts?
Sure. The individuals who have been detained are nothing more than individuals who are suspected of involvement in terrorism. They're nothing more than that. And for us to assume that they are incompetent, or for us to assume that they are in need of psychological counseling is, I would find to be, what's worse than outrageous plus. They're nothing more than suspects. And for us to engage in indefinite detention, however you want to model it, however you want to spin it, I would suggest is clearly unconstitutional. There is absolute need. I can't emphasize this strongly enough.
But you want to...
Wait,
sorry. Okay.
2 seconds. There's an absolute need to not tomorrow, not today, but yesterday, to establish a criteria-based vetting process. Otherwise, it's nothing more than round up the usual suspects. Engaging in voluntary incompetence strikes me as untenable and unconscionable.
But you do want to punish people based on future,
no, I want to
future
punish
dangerousness,
no,
right?
I want to, no. Again,
what is the criteria then?
The criteria, first of all, for establishing this vetting process is based on intelligence information vetting to determine who presents a potential threat. But you're not going to try them for being a potential threat. You can only go forth with a trial with respect to these people based on intelligence information if they present if you believe they present a threat, then you would have to indict them based on crimes that they've committed in the past. But it's absolutely essential that the criteria be future rather than past. But you would try them on acts they've done in the past. Some people, for instance, Hamdi, we talked about Hamdi earlier. I recall it was either Hamdi or Hamdan committed the really serious crime of carrying a gun in Afghanistan. If I lived in Afghanistan, right? If I lived in Afghanistan, I'd have a tank. That's not a crime. That's not a reason to detain somebody. X percentage of the people who've been detained have been detained because sources were ratting on them for, involvement in their, without getting into details, but, personal crimes, crimes of morality. Those people need to be vetted. Those people need to be released.
All right, let's pass the mic down and see if we get any more responses.
Remember I told you at the last panel that I was not a constitutional expert, so now forget that. I agree, it's unconstitutional, administrative detention under these circumstances. The kinds of laws that are on the books and have been deemed constitutional concerning dangerous individuals who lack mental capacity or juveniles or individuals who can be detained after the completion of their sentences in connection with sex offenses are qualitatively different situations than the one in which you want to detain a person because you actually suspect that they have committed criminal activity. If we have an administrative detention scheme for these people, then why would a prosecutor in his or her right mind ever bother with a criminal charge? It is the quintessential slippery slope. Plus, I would ask anyone who's considering administrative detention to also bear in mind the nature of substantive criminal law that is already on the books in the United States. Some of the most far-reaching types of criminal responsibility exist in the realm of terrorism. Material support. Material support is a crime that is probably easier to prove than even the broad and often criticized crime of conspiracy. If a prosecutor can't prove a material support charge against someone who is actually suspected of and there is evidence of their involvement in terrorism, then I would submit that there is no basis for the administrative detention of that person either. So, quite aside from the fact that administrative detention I do think is unconstitutional in the U.S., I think there is also no practical need for it, and once again, the larger costs of administering such a process would certainly outweigh any of the potential benefits.